A counterclaim is a claim by a defendant against a plaintiff. So if Paul sues David for negligence, and then David comes back and says, I'll see your negligence and raise you with intentional battery, that's a counterclaim. A cross-claim is a claim between two co-plaintiffs or two co-defendants. So if Alice and Betty sue Charles and David, and then Betty turns around and files a claim against Alice, Betty has cross-claimed against Alice. So too if Charles files a claim against David. Rule 13a compels defendants to raise counterclaims against the plaintiffs that arise out of the same transaction or occurrence as the plaintiff's claims, if raising the counterclaim will not require adding another party that the court has no jurisdiction over. If you fail to raise a compulsory counterclaim under Rule 13a, you've waived it. You have to get it in now if it relates to the same transaction or occurrence. Rule 13b permits any two parties in an existing action to bring any and all claims against one another, even if unrelated to the underlying suit. Let's give you an example of 13b. Clara sold her ex-husband Jim the house that they lived in together prior to separating. Clara, feeling quite vengeful, turns around and sells the property to someone else before Jim moves in. Jim sues Clara for breach of contract. Clara, if she wants to, can now counterclaim for 10 years of assault and battery against her ex-husband. Her claim obviously has nothing to do with the transaction or occurrence that gave rise to the suit, namely a contract dispute, breach of contract. But Rule 13b allows her to do it if she wants to anyway. Needless to say, the character of this litigation has changed. It was a simple contract dispute for which Clara was pretty clearly liable, probably wouldn't have lasted very long or cost very much money, to a contentious family law and tort dispute that will be highly fact-bound and probably take a long time. The assault and battery case will literally take over the litigation. We allow this to happen for the same reason we have permissive joinder rules. We want to get the parties to air out all of their disputes at once, in one forum at one time, to avoid, where we can, duplicative litigation. Now in this case, it seems pretty ridiculous to litigate the breach of contract and the assault battery claim in one trial. We have a remedy for that. It's called Rule 42b. 42b gives the court on its own the authority to split a proceeding, so you'll have two trials arising out of the same proceeding, and that's probably what would happen here. The court would allow Clara to bring in all of her claims against her ex-husband if she wants to, but the court would then split them into two separate trials. We would have one trial for breach of contract and one trial for assault and battery. If a counterclaim necessitates or militates the addition of a new party, Rules 19 and 20 relating to joinder govern, and not Rule 13. Don't assume that just because Rule 13 compels or allows me to make a new claim means that by necessity I'll be able to bring in the new party. You do not look at the cross-claim or counterclaim and decide that it's really important, and therefore bring the new parties into the suit. Rather, you start with Rule 19, deciding whether or not to allow this counterclaim or cross-claim to go forward. Figure out whether the third party is indispensable to the litigation. Chances are he isn't. You then move to Rule 20, figure out if the rules of permissive joinder allow this party into the case. If they do not, the cross-claim or counterclaim isn't going anywhere, even if 13a or b seems to allow it or maybe even compel it. Third-party defendants under Rule 14 must raise compulsory counterclaims and may raise permissive counterclaims against the defendant. Remember, the third-party defendant is to a typical defendant, a third-party defendant is to the defendant as a regular defendant is to a typical plaintiff. So when assessing the relationship between the defendant and the third-party defendant, just think defendant and plaintiff. All of the rules relating to counterclaims from a defendant to a plaintiff apply from the third-party defendant to the defendant. Third-party defendants under Rule 14 may raise claims against the original plaintiff, that is, skipping the defendant and going straight to the plaintiff, only if they arise out of the same transaction or occurrence that is the subject matter of the plaintiff's claim or claims against the third-party plaintiff and against the defendant. That is, the claims that make up the original dispute. So here's another example where Rule 14 changes the dynamics of litigation a bit. Typically, as we said, defendants can raise any counterclaims that they want to against the plaintiffs. A third-party defendant is limited in what he can raise against the plaintiff, only claims relating to the transaction or occurrence that is the topic of the suit. Additionally, as we said before, co-parties may raise cross-claims if the claim arises again out of the same transaction or occurrence that is the subject matter of the original action or of a counterclaim, or if the claim relates to any property that is the subject matter of the original litigation. So cross-claims are much more limited than counterclaims. Remember, counterclaims from a defendant to plaintiff can be very broad, and over a broad number of issues, cross-claims are very limited. Co-parties, as we said, cannot raise any cross-claim whatsoever. Because the rules between cross-claims and counterclaims are so different, it's important that you keep straight the difference between them. If it helps, think about it as a game of full-contact volleyball. Just created a new sport. Players are encouraged to throw stones and shoes over the net if they want to at their opponents, but not at their teammates. If you want to make your teammate look like a fool, you throw him the ball and hope he messes up. Similarly, when fighting with someone on the other side of the V, you can air out all of his dirty laundry if you want to. But when fighting with someone on the same side of the V, you're limited to the basic material that is the topic of the suit.